नमस्कार फ्रेंड, आप सभी का एक बार फिर से स्वागत है। फ्रेंड्स, केरला हाई कोर्ट जजमेंट ऑन पेंशन अपडेशन, इस बारे में श्री सी एन वेणुगोपालन सर ने एक डिटेल्ड इंफॉर्मेशन भेजी है। डिफरेंट व्यूज emerge फ्रॉम द retirees fraternity on the judgment in WPC Ravindran versus Union Bank of India and Union Bank of India. Union of India and Union Bank of India. Some opined in a disappointed mood that there was not direction to the respondents to update pension and the lamb was left before the lion once again. Others said that it is a purposive judgment with definite advantage. Since the argument against the judgment need no explanation, let us dwell upon those supporting it. First, since Regulation 35(1) is adequately interpreted properly in paragraph 4, it augurs that affidavit of IBA in M C Singla case that there is no provision for updation of pension in the pension regulation. The judgment came at the right time for the producing in the Supreme Court. Second, the judgment interprets Regulation 56 to take to a conclusion that the pension scheme in the bank is akin to the central civil pension scheme where pension is updated. Third, the contention of IBA that there is a paucity of funds in the pension fund gets uprooted by stating that only 23.91% of the annual growth of the pension fund is paid as pension. Fourth, the judgment identified the purpose of pension fund and funds that is will have no use later as the pensioner is a vanishing community. Fifth, though the second respondent bank is directed to consider the representation of the petitioner, the representation has to be considered with cognizance to the observation of the court. The bank cannot disregard the valid observation of the Honorable Judge. 6. The Honorable Judge has exhorted that a holistic approach has to be there in pension matters and a constructive interpretation of the regulations cannot be there. 7th, since the judge has given a mere direction to consider and dispose of the representation in 2 months' time, which ends on the 26th November 22, without giving a straight direction, the respondents may not be in a position to challenge the order in appeal. 8th, in case of an appeal coming since the judge has not erred in any score, the appeal is likely to be dismissed at any rate. And 9th, if the bank is not passing an order as directed, the petitioner can move an IA in the same petition which will be considered by the same judge in the chamber itself in a day or two without posting in the open court several times. A state order against the bank can emerge then. 10th, I could raise a claim for updating my pension on the basis of the judgment and also alleging misuse of pension fund by paying pension out of it to whole-time directors when the bank admitted the breach of pension regulation and stated that it happened at the behest of DFS. 11th, the contention of the bank that updating of pension needs further instruction from DFS/IBA is unfounded as A. IBA is not an authority to give instruction and B. the pension regulation carry provisions sanction of the DFS are adopted by the board of the bank and notified in the Gazette by the DFS and needs no further instruction for their implementation in letter and spirit. Let all of us remain positive on everything. Shri C. N. Venugopalan. Thank you friends. Namaskar.